Thank you for taking your time out to come and listen to pensions. You probably didn't wake up this morning thinking, wow, pensions, but thanks for taking the time out of your busy week to listen to it. My name's Mark Jones. I'm from Assured Wealth and Estate Planning Limited. I'm the National Trainer on Pensions and Divorce Matters for the Family Mediation Association. And I've been training pension and divorce issues since 2017, primarily through resolution pods UK-wide. They were face-to-face prior to COVID, but most of them are being online now. And with the help of family lawyers, I've developed the only online portal in the UK to deal directly with instant quote requests and litigants in person. So we deal primarily with mediation clients, clients who are going through mediation where the other big firms won't deal with them generally. We've built a system around helping those people to understand what they've got and to interact with a pensions on divorce expert as well. And we can turn the reports around in around 6 weeks, so with one of the UK's fastest firms as well. But what do we do as a firm? We solely focus on divorce, so we produce expert witness reports. We're going to look at today something called the Pension Discovery Meeting Service, which I feel is something that's long overdue. And we'll talk about trying to influence resolution and the resolution team around trying to change things. We do cash flow modelling, so we help the clients understand if there is finances to be shared or pensions to be shared, what that looks like in terms of income each month. We do estate planning following the divorce, so lasting powers of attorney, updating the wills and placing assets into trust. We implement pension sharing orders, and we also, for mediators and solicitors around the UK, we offer this 15-minute free Meet the Expert session. So if you're sat in mediation with a couple and pensions has come up, or you're not sure of something and you're not really sure where to turn, you can simply book a 15-minute session with our team. It's online. Ask you questions. If we don't know the answers, we'll go away and find it for you. There's no charge for that service. We're here to offer a service of help and support, really. My background is in stockbroking, financial advice, and estate planning. Okay. So in December, I ran this session for the FMA, and I asked the question, who in today's session could answer exactly what age they will stop working and draw their retirement income? And when I talk about retirement income, is how much that gross annual income will be that you will receive in year one, and will that be sufficient to meet your retirement needs? And surprise, surprise, nobody on the call can answer it, and that's nothing new. My personal financial planning clients can't do that when they first come to me. As a financial advisor, you have to help people understand what they've got and how to make sense of it. And realistically, that's what you're doing through this service, is you're trying to make sense to your clients of what the pensions will look like and when they can possibly stop working and start drawing down retirement income. But for the mediator, these are the issues really. You're trying to maintain this collaborative approach towards the parties' pensions that reduces conflict and possible spousal intimidation, and yet still be able to guide their clients towards understanding how important their pensions assets are. So that is the education session that we'll talk to you about shortly. And the session may then recommend having the assets formally assessed, therefore helping them to draft a suitable letter of instruction to an expert if a formal assessment of their pension is required. Now, typically in the last 2 years since we've been running these sessions, mediators are very reluctant to be drafting a letter of instruction to a pension expert for various reasons that we don't have time to go into today. But I think once you see what we're doing towards the mediator community, you'll feel a little bit more confident in helping your clients actually get to that stage as well. So just wanted to make you aware of this research that Emma Hitchens did from the Bristol University. And when I saw this last year, I was really shocked. I wasn't surprised, but I was shocked at the depth of kind of the problems that women are facing going through divorce. So in 2021, 113,505 divorces were granted in the UK, up nearly 10% on the previous year. Surprisingly, only 2 in 5 divorces used a lawyer. The median total assets divorcing couples own, including the property, pensions, and taking into account any debt, was just £135,000. Now, I do take a little bit of if you like, with Emma at this stage, because she isn't really taking into account state pensions, and I think that's a big miss. I think she's missed an opportunity here to discuss state pensions in the research, and we'll show you what the state pension's worth in real terms when we have a look at it later on. 1/5 of couples have no assets at all to divide. Just 1/3 of divorcing couples finalise their finances through a court order, and only 10% of cases get to court. Pension sharing is included in just 10% of divorces. So 10% of those 113,500 divorces resulted in the pension sharing order. Now, when I saw that, I was quite shocked, because pension sharing legislation has been around for 20 years. And yet we must be fundamentally doing something wrong as mediators, as IFAs, as lawyers, as barristers, for women generally not to be placing a charge against the ex-spouse's pension. And only 2 in 5 divorces use the lawyer for information, advice, or support, often due to the fears of cost. And I think the fear of cost, intimidation, and not understanding pension is a starting place for us as an industry to look at how can we try and resolve that. Only 1 in 10 sought no advice or information to help them with their divorce. So I'm not sure whether those statistics surprise you or not, if we've seen this research from Emma, but I was quite surprised. So only 10% of divorces end up with a pension sharing order, which that can't be right, can it, surely? 1 in 5 divorcing couples have no assets to share. And then you looked at some other research that happened in 2021. So the Manchester Institute for Collaborative Research on Aging said that pension inequality is a major issue when couples divorce. And we see that, and anecdotally we see this as well, is that women feel more emotionally attached to the matrimonial home, whilst the husband generally views the pension assets to be his. Now, there's evidence to back that up, there's anecdotal evidence, and there's probably meetings that you're sitting in probably this week and last week where these conversations generate around this. And then what we do as a firm, for all the pension sharing reports that we produce, we're constantly looking back at the last 250 cases, and we produce an ongoing aggregate value. And this tells us that just under 90% of cases, men have more pensionable income at their target pensionable age. And this includes state pension as well. But let's put it into context. What does that actually mean? In average, men have at retirement £35,000, where women have just under £20,000. There's a massive gap. And if you're not educating your female clients in the relationship breakdown, that's the depth of value that they're losing on an annual basis, then we're not doing something right. And we're being let down, as I said. So what is the issue then? So I have these conversations every week with mediators and family lawyers to some extent, that we're attempting to send clients down a pensions assessment road that they, and possibly you, need help understanding. And they see no benefit from it, only more expense. So you've got a couple going through mediation or going through a process with lawyers. It's very expensive in their opinion, and pensions is an asset. They don't understand. They don't understand what they're losing, and they just see it as a big expense. On top of that, we've also got the other issue, is that possibly intimidation plays a part of this. Again, just working with mediators and lawyers and looking at some of the issues that some of the cases that have come up and some of the pension discovery meetings that I've hosted, you can see that the husband didn't want to come to the meeting. He didn't want to do the full and frank declaration. But as part of that, coming out of the divorce on an equal footing, there has to be some honesty, really. So we're going to look at a case for Mary and Robert Smith. Mary's 57, she's a HR director. Robert's 59, he's a civil servant. And this is a quick snapshot of their pensions. So you can see here that Mrs. Smith has got a final salary pension with AstraZeneca. She's got a personal pension with Prudential and one with AXA. And the value of those assets are £805,544.39. So the CETV from AstraZeneca is an internal mechanism that they valued the future benefits as a cost to them as a company, as a pension. And the two personal pensions are actually what the fund values are at the moment. Mr. Smith's got 2 civil service pensions, and he's also got a Hargreaves Lansdowne personal pension. And for illustration purposes, the pensions are almost equal. So if you were sitting in your office and the clients declared this situation without sitting down and doing an education session with the clients might simply think, our pensions are equal, we'll just ignore that as an asset, and we won't bother about sharing anything. We won't even get it assessed. And that's a bit of a misnomer, really, because you're not kind of judging eggs with eggs, or apples with oranges, I should say. You're doing more likely. So you'd ask yourself, do they require a pension expert witness report? And if yes, why? And I would think, looking at the size of the assets, almost £1 million each, the first question should be, they're in excess of £100,000 each. The Pension Advisory Group in 2019 said they should have a polled witness report. Which is the pension is the dominant pension? Well, that's very difficult to tell from that, because everything on the face of it looks fairly equal. The final salary pensions look pretty equal. The personal pensions in value look pretty equal. You can't really answer that question without kind of doing the analysis in the background. And if a poll report recommended a pension share, which do you think it would come from and be paid to whom? So looking at that, you think, well, they don't really need an expert report, but if one was formulated, where would it come from? So I'm going to show you the answer to that question now. So this is how it washes out. Those pensions are taken forward, and both parties should have around £54,556.89 in pensionable income each year at the target date, which means that Mr. Smith has to share some assets with Mrs. Smith because she's got a slight shortfall of £2,766.89. And when the POD's done the research, produced the calculation, they've also looked at the pensionable assets, which are these, and said, from which of these pots should it be shared? And they decided it comes from the Hargreaves Lansdowne pension. Now, there's lots of reasons why it could be shared from the final salary, but there's equality across defined benefit, final salary, because she's got an AstraZeneca one. So in this case, the POD chose the Hargreaves Lansdowne one from Mr. Smith to Mrs. Smith via an external transfer. So you've got this problem. You've got this problem that pensions are being ignored on divorce. Clients think it's complicated, it's too expensive. You've got to get a POD report, and then you've got to have a pension share and annex produced. You've got to get the final consent order signed off by the judge. It's just really confusing. Why don't we just leave it alone? I want to stay in the family home. He can keep his pensions. So we've come up with a solution for you. And this started with a trial in September 2022 with 9 family lawyers. And for me, the focus was on educating the clients before drafting a letter of instruction. So predominantly, letters of instruction are something that the solicitor would generally have done because they've got a template and they've used that template. And they're asking lots of questions, some of which may be relevant, some of them that are not. So the trial tried to flush out what were relevant questions for a letter of instruction. And this was the research that came out. The parties felt involved and listened to as their personal needs and goals were heard. The letter of instruction had a maximum of 2 ages for calculation and just 1 age and reduced accrual being assessed. That produced less negotiating post the pension sharing report. And it was much easier to explain to the clients. There were 0 questions regarding the findings and how the pensions could or would be shared. And the reason for that is because, as the experts, we're telling the clients at the beginning, before it's even been sent into a POD, this is what things may look like. This is how your pensions work. And in all likelihood, you're going to possibly share in one of these 2 pensions. Offsetting was the reports focusing only 1 out of 10 reports. So I think sometimes as an industry, we're kind of trying to work out what's the cost of not sharing the pension. But in the research that we did, only 1 in 10 actually needed that figure anyway. Both parties could see the income spreads. So just like I showed you before with Mr. and Mrs. Smith, it shows you a forecast in the education session about what the pension's currently looking at giving you. And that came across and it said that CETVs were meaningless. So the actual notional value that a final salary scheme places on a pension income is meaningless because it's the income that's important, not the CETV. And lawyers and mediators no longer attend the sessions. It saves money and it works. And then post the report being done, we come back to the couple and say, this is what we told you. This is what the report said. Do you have any questions about the report, the implementation service? And that 15-minute session at the end is free. So the lawyers that were on the trial and everybody that we've worked from since have since gone away. They've torn up the framework within their own practices and started to look at this framework. So educate the parties on what pensions they have and how they may be shared. Include a POD service. So we're not today saying that assured wealth is the only way to do this, because if you started to do that, we wouldn't be able to service you anyway. What we're trying to call for today is for you to work in partnership with financial advisors in your local area who would be able to offer possibly an education session. We do it at £300 plus VAT. I'm not sure if anybody can offer it at that price, but we are calling on the financial services industry to help support people going through divorce. From that, in our session, we then help the clients to produce a letter of instruction. It's 75% done by the time they come off the call. And then they may just have some comments and questions for you as a mediator, which you could probably help top and tail. And then that's submitted to a POD. They produce a report. You then obtain the report and review it, understand the report and ask questions of the expert if necessary, then negotiate between the parties. And then if it's an internal pension share, you don't need an external IFA to help you with that stage. But if it was going externally, you would have to engage with an IFA at that stage as well. So how can you educate your clients about their pension assets? We call it the pension discovery meeting. It's an education workshop, really. And I'm going to show you 3 slides now for a case. But before we do that, we have to cross the bridge of safeguarding. Now, if your clients are in mediation, hopefully there is no issues around safeguarding and for us, but we've all attended the resolution screening and safeguarding training. So we offer them the opportunity to have the cameras on or off. They decide before they come on the call. And if there is safeguarding issues, then we'll split the hour session up into 2 30-minute slots. So you might come on as a mediator with Mrs. for the first 30 minutes, then you might come back on as the mediator with Mr. in the following 30 minutes. We're there to kind of be advised by you, the mediator, around safeguarding and lack of coercive control. If I'm running the session and I feel someone's being coerced, I'll stop the meeting and we'll rearrange it back into 2 30-minute slots. So what does it look like then? 3 really busy slides, but this is what your clients would see on the screen. So this is Brian Jennings. He's 55. He's born on 8th of Jan 1968. In this session, if there's a box in orange, it's the questions that I'm asking of the client at that stage. So he declares in the meeting that he's got PTSD. He's ex-armed forces. You can see he's got an armed forces pension in payment. He's almost got full state pension contributions, so he's almost got the full state pension. He just needs another couple of years and then he'll have a full state pension equivalent. His state pension age is 67. He's currently employed as an engineer. He can access his personal pensions today from 55. There's no issues with that. And he doesn't have a financial advisor. So we get talking about his PTSD, how it's affecting him day to day, how it affects his work as an engineer. And he says he thinks he's going to be able to work until he's 65. Are any of his pensions in drawdown? Well, not his personal ones, but he's in receipt of his armed forces pension, and he has taken the tax-free cash from that. So again, we'll talk about tax-free cash shortly, because that's important from a calculation point of view and looking at marital assets as well. He's then got final salary with the local government pension scheme, a career average with local government pension scheme, and as I said, his armed forces pension scheme in payment. So they're all what's called defined benefit. So the benefit is defined by the contract. So you can see there, his income forecast in the orange box towards the middle is giving him a forecast income at the moment of £19,210.81. He's also taken £22,532 in tax-free cash, so he's already had that. He's got at the moment 9,235 state pension. And then we look at these two personal pensions that he's got. He's got Rural London and People's Pension. They're currently worth £35,775.97p. Now, what the experts do is they convert that capital by using an applicable annuity rate. So that's the percentage share that you get when you cash your personal pension in and you buy an income for life or an annuity. So that £35,000 would give him an income for life of 1,674. So for Brian, he's got state pension, defined benefit, and annuity income, and those three elements combined right at the very bottom give him a forecast income of £30,120.49p. Now, depending on his illness and if he's got any ongoing illnesses, he may qualify for an enhanced annuity, so he might get a higher rate than 4.68%, but he doesn't think so, and I didn't think so based on the questions that he gave me, or the answers that he gave me, sorry. And this is Emma. She's a year older. She was born in '67, and she's got breast cancer at the moment. She hasn't got a full state pension record, and that's important to understand that she's got another 6 years shortfall. So she's got another 6 years of national insurance contributions that she could make to qualify for the full state pension. Now, when you get someone that's got an illness like breast cancer, they may not be able to continue to work till age 67. So this is a really important element we need to look at and chat to her through. She's employed for the Department for Work and Pension. She doesn't have a financial advisor. She thinks she can go to 67 and none of her pensions are in drawdown. She's got local government pension scheme with Avon. She's got two elements. She's got the early one, the 80th scheme, and then the 60th scheme. So they're both final salary, defined benefit. And then she's got career average with local government pension scheme as well. So again, we look at her state pension and her defined benefit. And she's also got a small additional voluntary contribution plan with Prudential that she started in 2008. That's worth approximately £37,000. So again, we convert all those using the same metrics as for him, and that gives her a forecast income of £26,055.42p. We go through all the other scenarios, and it's interesting to point out for her as well, is that she would have to work until she's 67 to not face early retirement factors in her career average scheme. The same as for Mr. Jennings as well. So this is when we summarise it, and this is what it tells you, is that Brian's got 30,000, she's got 26, so there's a shortfall there in favour of Mrs. Jennings of around £4,000 a year. The next box, the £20,460, what's that all about? That's some research that was done by Which. So the Which magazine finance people looked at what would you need to have as income to have kind of like an average life where you had a couple of weeks holiday a year and maybe a couple of weekends away as a single person. So you can see they're both on track to have a nice, comfortable planned retirement as long as they get to 67 with full state pension entitlement. Brian's retired early already, and if he starts to take any of his other elements, he'll lose his some of his income as well. So some of the early retirement factors will kick in. And in the session, I explained those in a bit more detail to them. It's not the case for Emma, so she's fine. But they've possibly both got health issues that might impact them being able to work till 67, the incomes that they'll face in the future, but offsetting wasn't a main goal. So then we summarise the session, and these 3 documents that you've just seen as the mediator in the case is what you'll get via an email from us. So we start off, there was no safeguarding issues, both happy to be on the call. There were no other parties on the call. The cancer diagnosis should be underwritten for a possible enhanced annuity rate. If agreed, both should go for underwriting. So what I said to him on the call was, he's got some issues where he's being medicated, and we should get him looked at for an enhanced annuity as well. Offsetting was explained in detail. Neither party wanted to explore this. With a possible share required, Mr. Jennings would be requesting the expert to utilise the civil service pensions, as he requires the armed forces pension income. So in other words, when you're calculating the benefits, don't share my armed forces pension, because that's in payment and I need that to kind of live at the moment. Both parties have over the 20,000 threshold, and the local government pension scheme can be both internal and external. Mrs. would prefer an internal route if possible. So what does that mean? So the local government pension scheme allows you to become an internal pension credit member as the ex-spouse, or you can take a lump sum from the pension and move it out, invest it, and then purchase an annuity at a later time in life. When we talked about the security of joining the scheme against taking it out and having the investment risk, she wanted to look at both, but she really wanted it to go internally. And then when we look at state pension, you've got this opportunity till 2025 to purchase up to 6 years national insurance record. So he could, Mr. Jennings could give her about £5,500, and she can buy back the missing state pension record that she might not get, because one of her concerns in the meeting was, if my cancer gets worse, I'm not going to be able to make up that shortfall. If that's an agreement, then the expert needs to factor in that she will have a full state pension as opposed to a smaller state pension. And they agreed to use one age 67 for Mr. Jennings, and the target date for calculations was the 8th of Feb 2035. Most importantly, neither party wanted to look at reducing pension accrual outside of the relationship. So they didn't want to chop off the bits pre-relationship or post-separation. Even though they did give us the marriage dates, it's a very short marriage. So then what happens at the end of the meeting is a summary pack sent to all the concerned parties. So the divorcing couple get a copy, the mediators and the lawyers, and then discussions take place. Very few questions are asked of the IFA. So what happens is you get the 3 documents plus a letter of instruction to uphold, 75% done. All you really need to do as the mediator in that session is confirm what was discussed. Do they have any queries or questions? And how can we finalise the last 25% of the letter of instruction to an expert? A letter of instruction specific to each person's practical concerns to uphold are agreed. This is worked through in a session, so there's very little to complete. Or in some circumstances, you might say that even though they've got quite dramatic changes in capital values, the income forecasts are almost there or thereabouts. And as an expert, if you can't justify them spending a couple of £1,000 getting an expert witness report, and then all the legal costs for the annex being produced and the implementation, it might be that they then simply say, no, thank you very much, we've looked at that, we're going to leave pensions alone. We will send them a covering letter to say that it's been assessed and we don't feel that they should proceed on that basis. And if you think about the Cunnington's case, that's really important to kind of cover yourself from as well. Because if you do draft a suitable and practical letter of instruction to uphold, if you don't do that, you might get too many calculations, really complex findings, confusing for the clients to interpret, difficult to implement in practice, and too many questions from the clients as they don't know what the report states, what it does. So there's probably lots of people on this call today thinking, I've had this. We've asked the clients to go to an expert. The PODE's produced this massive big report. I didn't understand it. They didn't understand it. We don't seem to be any better off than when we first started. And this all relates to time, cost, delay, and frustration, which is what we're trying to avoid in the first place. So normally we'd ask questions at this stage, but because we're tight on time, we're going to push the questions to the back. So what I'd say to you is, if you've heard anything in the first session there, please just click on your chat box, ask any questions, and feel free as we're going along, ask any questions as you're going along, because my colleague Sharon's on the call. She'll summarize these into a Word document, and we're going to, when we close the session at around past, I know most people are not in the next session till 12. So we're going to do one or two things. We're going to talk through some of the questions that have come up. If some people need to get off at past, that's fine. We'll summarize all these questions and we'll submit it back to the family council, and they'll share the answers with you as well. Okay, so let's go back to basics then. So this is all to do with data collection, and we have got a process built in for you to do this, but we're going to send you and your clients back to basics, because the PAG report and maybe some processes that you've already got in place sends the wrong documents to the wrong people at the wrong time. I'll explain why. So I want you to unleash your Amelia Fox for me, if you don't mind, when you're looking at data gathering. We kind of need to dig down to the detail. So if you took your car to a mechanic in the olden days, you'd use spanners, hammers, socket sets and everything else to do your car. But what we really need is more of a diagnostic check. And there's some tools that enable us to do that. So these forms, please don't use them. Please don't use the pension inquiry form, because they don't get enough data. What you need is a letter of authority request. So if we get a client who's a financial planning client, we need to dig down into that contract and understand warts and all. So you can use, if you're working in tandem with a financial advisor, use their letter of authority forms, send it off, get the full details of that contract. Please don't use the pension inquiry form for that business. Summarize the pension assets being assessed, so use a table. So pretty much like you've seen before, when you send that into the PODE to be assessed, so you're summarizing what the clients have got in this case. If they're coming in to do one of the educational sessions, this is how you'd format your instruction to us or to an IFA that you're working with. So let's deal with tax-free cash then. That has been taken. Is it in or out of the assessment? You need to help them to decide, really. So let me just explain what's available to you. So this is in personal pensions. Personal pensions in general allow you to take up to 25% tax-free. Now, different contracts do different things. There are some old contracts knocking around that allow you to take up to 35%. So there's a caveat there that 25% is kind of what's generalized now, but there are some existing contracts that are out there that allow a little bit more. But these are personal pensions. This is not final salary or career average. So if they have been taken, we've got an example here from Mr. Smith drawing down 2 personal pensions with Aviva on the 1st of May 2018 for a total of £123,098.56. And you have to ask yourself the question when you're sitting with the clients, that money that came out in 2018, where did it go? Was it used inside the house as a couple, or has he simply taken it and put it into his own account that he's ring fenced? Is it got to be classed as a marital asset then, or is it going to be ignored and therefore ignored, or not, and it should be added back in? So let's just work through the scenarios. You agree in mediation that that was a marital asset. You tell the PODE to ignore it. If you agree in mediation that it wasn't a marital asset and he's used that for himself, then that should be calculated back in. And what the experts do is they give him the £123,000 back as of the 1st of May 2018, and they calculate that capital growth forward and convert it to annuity at the target date. So it's really important to understand, if tax-free cash has been taken, And sometimes you won't see that in mediation unless you've got the documents like a letter of authority form from a financial advisor. Let's just talk about big changes to pension ages are coming then. With an age gap, don't ask for what can't work and obtain feedback from the pension discovery meeting. Okay, so as of the 5th of April 2028, pensions legislation changes. So at the moment, you can access personal pensions from age 55, no problems with that. But on the 5th of April 2028, that's moving back to age 57. So in other words, if you were born on the 6th of April 1971 or afterwards, you can't access your pensions from 55 anymore. And what the government are doing is they're using this 10-year time lag. So personal pensions will lag 10 years behind the state pension age. And you can already see that the state pension age is kicking up towards 68. So at some stage in the future, this will move from 57 to 58, although legislation is just not there for it just yet. If the ex-spouse is getting an external transfer, consider when he or she is age 57 for access to the tax-free cash and income should he or she need it. So there's absolutely no point sending a letter of instruction in that says, can you equalise benefits at age 55 for both parties if you already know that they fall foul of this change in legislation? Again, through the education process, we would have explained that to them. If someone was born post 1971, we'd have explained to them at that stage, so they would know coming back to you, okay, well, we can't take it at 55, it's going to be at 57. Now, they may be thinking about drawing some of that cash to, rehouse themselves, or if the wife's staying in a former matrimonial home and the husband's looking to get access to some capital to house himself, that may be a little bit of a shock that he's not going to be able to take it at 55. It's going to be a couple of years later. But again, this session today is about giving you a little bit more information, really. And then we want to look at difference between ages between the couple, because this is a really important element as well. So this is when you've got a final salary pension where there's an age gap. So Mr. Smith is 9 years older than Mrs. Smith. We receive a letter of instructions that says, please equalise incomes for the parties using the dominant pension at age 55. Well, straight away, whoever's written this letter of instruction hasn't understood the prerequisite that 55 for whom? Is it 55 for Mrs. Smith? Because if it's 55 for Mr. and you've had that conversation with the client, then that practically won't work because she won't be 55 at that stage, so we can't get any meaningful data and run any calculations for it. But suppose the dominant pension in this example for Mr. Smith is the Armed Forces Pension Scheme. And Mr. Smith has a CETV for that scheme of some £334,098.08. In that case, Mrs. Smith cannot access her Armed Forces pension credit until age 65 without an actuarial reduction being placed on her internal pension credit membership. Wow, that's a mouthful, Mark. What's that all about? So, again, if you retire early from a final salary scheme, career average or final salary, and that's before the scheme's normal retirement age, and we'll look at some of them shortly. If you take the benefits early, then the scheme reduce your income and tax-free cash elements down as applicable. Because she's getting an internal pension credit, in other words, she's being made a member of the Armed Forces Pension Scheme because it can't allow an external transfer, you need to make her aware that the scheme doesn't allow an ex-spouse to take benefits before 65 without being factored in some early retirement factors. So you've got this really peculiar situation where you could have an Armed Forces Pension Scheme 1975, where he can take that from 60 without any early retirement factors. When you become an ex-spouse with an internal pension credit, they push that level up to 65. And you've got to look at, does she know this, what's practical? Use what's practical and ask the PO to run the calculations on that basis. So we're trying to change the emphasis around ages to dates, because when you talk about dates, that makes it more practical, and that's what we talked about in the pension discovery meeting. Because if you're looking at the relevant date, this is what happens. So you can see that he's, in this scenario, there's an 8-year age gap between Mr. and Mrs. Smith. So when Mr. Smith gets to 60 in 2028, his income, his pensionable income from all assets is £10,000 a year. You can see this on the sliding line from left to right. And you can see that £10,000 start to increase each year in line with CPI. So he's getting these payments each year, and he gets them all the way up for 7 years. And what you need to do is say, well, if we're trying to equalise benefits at age 60 for the parties, you need to take into account what Mr. Smith's already had when Mrs. Smith becomes 60 in 2035. So you take that £78,000, and on the 1st of January 2035, you convert that £78,000 into income with an applicable annuity rate for a 60-year-old, which is a 3.6%. So in other words, he's going to get an additional £2,812 a year at 2035, which increases his income. It's not 12,091 then. He's going to get that additional income factored back in, which gives him just under £15,000. So that's how the experts would deal with the age gap. Again, you don't have to have it calculated like this. And again, if they're going through education, we talk to them about this as an option and the option of not calculating it in, just taking the raw data at 2035. So just remember that if there's a big age gap, he or she will have received pensionable income before the other party hits the same age. If you're looking for equality post the relationship divorce, then you need to factor these in as well. And you can see that being highlighted there. Okay, let's talk about the elephant in the room then. And what is the elephant in the room? It's this, the state pension. It appears in PAG, in the PAG report, the Pension Advisory Group report. It appeared in the first one, and it's appeared in the second one that's just come out now. And you've got to ask yourself, why did the Pension Advisory Group report state that they're often one of the most valuable assets in divorce and should not be overlooked? Well, it's really simple. When you work out what you need to have to buy that income for life, this is how it works. To buy the equivalent income today for a 67-year-old would require £220,000. So in other words, if I'd been saving into a personal pension all my life and I got to 67 and I was going to get a £10,600 a year annuity, I would have to give them £220,000 of my pension pot. So don't take it. Sometimes you just hear the weekly figure of £200 a week, but when you think about it, for some people that's bigger than the housing asset that they've got. But then when you go back to the report for the Fair Shares Project, this is what I said at the outset. She said the median total assets divorcing couples own, including property and pensions and considering any debts, was just £135,000. That's why I kind of said she'd missed a trick here. And I think she didn't do the industry many favours by not adding the fact that if you've got a full state pension, and that's an additional £220,000 you've got in your armoury. And that's why it's really important to get the right documents at the right time. So using a document called the BR19 and the BR20, which we'll see shortly. Don't use the online valuations. So again, go back to basics, be forensic about it, use letters of authority, use the BR19 and the BR20 because they give you the full picture. If someone just goes onto the government gateway and they get the headline figure, so dear Mark, you're entitled to £203 a week. Well, actually, if you go down to the next page down, it'll actually give you what I've actually got in the bank. So if I've got a 9-year shortfall, that doesn't appear in the headline rate. It's only the bottom rate that we use for calculation purposes. And the difference in £20 a week can be several £1,000s a year, which is a big difference in what should have been shared between the parties in terms of a pension sharing order. Again, we're going to skip through questions. So, offsetting against the former matrimonial home. Again, this is pretty basic stuff, but sometimes the basics get missed as well. So what I wanted to highlight here is actually what's the equity, and we have to work out what the equity is. So The house valuation as of the 5th of October 23 was £425,000. So due diligence that you do here when you're doing forensic stuff is get the parties to get 3 independent valuations of the property, get their mortgage balance as of the same date, and then you've got the net equity in the home. And then is the house owned 50-50, or has there been some alternative purchases and registration at land registry for that property? You know, is it owned 70-30 or some other way? But what you need to give the expert is what is Mrs. Smith's equity in the property, because when you're looking at her staying in the former matrimonial home, you need to use that value of 150,987.32 against the pensionable assets within the report to give you some meaningful data, as opposed to if she stays in the family home, how does that reduce any possible pension sharing down against Mr. Smith's pension? McLeod, okay, it's the millstone around the industry's neck still at the moment, and it's still going to drag on for another couple of years. But I thought what we'd do in the next couple of slides is just put a bit of meat on the bones for you. So McLeod and Sargent were 2 cases that the government lost in terms of age discrimination. So what the government lost the case was they moved people out of a really gold-plated pension scheme and illegally moved them into worse schemes or watered down schemes against their own choice. And what the government have lost is now that the schemes are all having to put people back into the schemes that they should have been, but through a very narrow specific window. I'm going to explain to you now. So here's the NHS as a good example. The NHS did have a 1995 scheme. People then either moved or pushed into a 2008 scheme, which is slightly worse. You can see that the retirement age goes up from 60 to 65. And it's a 60th scheme. So again, it's a bit watered down as well. And then the 2015 scheme that most people were pushed into gets them being able to take the benefits at state pension age, depending on what your state pension age is. Now, obviously, the government couldn't afford to continue in the 1995 scheme or all the other unfunded government schemes as well, so they had to water them down. But it was that move from any time between the 1st of April 2012 and the 1st of April 2022, which is what the remedy talks about. So for some people, they stayed in the 1995 scheme right up till 2019, depending on whether they had protection or not. That's why it spans all 3 boxes. But in essence, they've moved people out of those 2 schemes into the 2015. And now the schemes are having to calculate what their benefits should look like and move them back. So that purple box there would move to the left, and you'll either get those benefits accrued into your 2008 or into your 1995. Now, this should have all been sorted out by October this year. And for the teacher's pension, that has been done. They pressed a button in the back end. Everybody knows what it looks like now. People's purple box, if you like, has gone down and the green box has gone up. And that's all hunky-dory. Everybody else is doing a bit of a myriad of stuff, and they'll tell you that they've still got now till 2025 to fix this problem. The NHS also introduced, as another thing to kind of protect doctors and keep doctors in the industry, was the flexibility to draw your benefits early and take a minimum of 20% of their income. So in other words, doctors can retire, take a minimum of 20%, and then come back next week as a doctor, to try and keep doctors in the NHS, because they're losing them hand over fist. And not just doctors, everybody that works in the NHS that's got really difficult job to replace, the NHS try to reach out to them and change some legislation. So not only have they got McLeod to deal with, they've also got this myriad around whether they take their full pension or not, or come back as kind of a bank worker. So not all teachers have yet decided to automatically move the career average benefits back to post 2012 into the final salary. So we calculate the benefits as it is now, but if a pension sharing order is made against one element and then there are automatic changes made to both elements, the clients can be disadvantaged. So you've got one of three options really. We'll skip through that. There you go. So if you've got clients that have got armed forces, local government, teachers, NHS, the police, civil service, any of those, you should be talking to them about your three options that you've got at the moment. You could basically pause this until the scheme fully implements the remedy, or you continue with your conclusions and get an expert report and don't factor any changes into account, or you continue with your negotiations, get the report, but just before you implement it, check to see what's changed and whether the scheme's implemented the remedy or not. And if that stage, then possibly get a recalculation of your expert witness report. As the schemes have not confirmed the time frame from implementing the remedy, there is significant risk with all three options. So waiting for some clients is not an option. Getting the report and continue as it is and hoping for the best. So in other words, in option 2, they get a report, they agree 40% of the NHS 2015 is to be awarded to the wife, but it goes into the scheme, and in that period between it going in and it getting implemented, they press the button in the background and she gets a lot less than she should. That's a really dangerous position to put the clients in. I think option 3 is probably the one that you want to go for, but again, it's case specific really. And we talked about the Pension Advisory Group report. Version 2 has just been launched. There is a copy on our website. There's been some subtle changes, but absolutely nowhere in version 1 or version 2 do we look after women. Has there been any plans or discussions around educating people, producing education workshops? And for me, that's been a massive missed opportunity really. So I've produced a poll on my LinkedIn page, and when I was thinking of doing this presentation to you yesterday, I was just going to give you Rachel's email address. I thought that's not fair. If 122 people start emailing Rachel, I think she'd really fall out with me. So what I thought we'd do instead is, if we just ask you after this session, if you could go to my LinkedIn page, or if you just search Mark Jones IFA on LinkedIn, you'll see this. And what I'd like to do with this is send this to Rachel on resolution and try and influence the industry to change so that we are educating both parties before they start to implement any actions towards a pension sharing report. Because if we can get the industry to do this, then that would be great. Because if you think about it, the government put in place a triage system for people that have got a final salary pension. And the final salary pensions say that you can take your benefits from a final salary, but you need to go to an advisor, which is a government-sponsored advisor for some education. So the precedent's been set. The government set up their advice clinics. They're already there. They would just need a bit more experience and a bit more training. But we could be in this position in a couple of years' time from now, where if you are a divorcing couple, you have to go to that educational workshop and you have to have been shown what your pension benefits look like for you then to be able to say, actually, we're going to just ignore that, or actually, that's a really good thing. I think we should get an expert witness report. So I'd love it if you could just take a couple of seconds just to click on that link, and I will share those results with Rachel. Okay, so we've got some next steps. How are we doing on time? Oh, great. So the first one will be complete the LinkedIn poll on my page. Train all the members of your team. So there's 121 people on the call now, or on the session. But we offer these sessions free, which is what we do as a business. All you need to do is go onto our website, and you can book a session for you and your team. Let us help draft part of the letter of instruction to an expert that's based upon what they need as a couple. We talked about that before. Please include a pension summary table in each letter of instruction. The template's in there as well. It's in our draft template letter as well. Please use dates and not ages, and consider age gaps between the parties and how important that is to understand that. Work out what's happening to all tax-free cash. Work through it if it's a marital asset or not. Use an IFA letter of authority to gather the data, not the Form P. And here you go, review some clients' cases who have unfunded pensions with immediate effect and advise the clients of the 3 options we talked about before. So again, if you're kind of delaying pension stuff because of McLeod, there are 3 possible outcomes for you. And again, it's just talking through that steps. Teachers' pension need urgent action if they've not yet been resolved. So if you've got teachers on your books that have had an expert witness report, but they've not implemented the order yet, that is a massive red flag. That's the most key priority case for you. If you want help with it, come to us, we'll explain what to do. It needs recalculating because the benefits have already moved behind the scenes. Remember your female clients, they're getting a really poor deal. For me, they're getting let down by the whole of the industry, not just the legal services and mediators, it's the financial services industry as well. We need to do more, we need to start shouting about this. Delete the Form P, it just doesn't work, doesn't give the expert enough information. And if you need to know more, just please book a 15-minute free guidance call. And there's a really long booking session now, you'll see it here. Again, we'll share these links with you as well. Our website or email address, all those other things are on there for you. So what I'm going to do now, we've got a couple of minutes. I'm just going to stop sharing that and see if my colleague Sharon's available to ask any questions. It is 11:30. If anybody needs to leave now at 11:30, that's fine. We'll still keep recording the session. This session will come out to you. And any questions that get raised between now and 12 o'clock, for those people that want to stay on, we'll try and answer as many as we can. Are you there, Sharon? Can I hear you? Very quiet.
Mark, she seems to have gone.
Okay, I know she has some technical problems this morning, so I'll go through the questions then. So Frank asked a question, Frank Orton. He said, roughly what does the expert witnesses report cost clients? They can be anything from £1,000 up to £3,500. We have ours start at between 995 and 1395. How long does it take to get a polled report? The industry standard is around 6 months, but if someone's come through a pension discovery meeting with us and they then submit a letter of instruction, they'll get the report back in 6 weeks. Yeah, she's put a couple of links in there as well. Can you tell us again the cost of your pension discovery meetings? That's from Kate. Yeah, they cost £300 plus VAT, Kate. So that £300 covers off the consolidation of all that data once it comes in. So we wait for all the information to come in and the team populate those screens that you saw before. And then we give the clients an hour education once we've got the screens produced, which also includes drafting most of the letter of instruction up to a stage of maybe they've got 1 or 2 questions they need to clarify with the mediator. We can't seem to be influencing a letter of instruction anyway, so we can't fully complete it for them. We can get most of the data in there, but it's got to be independent of us. They've got to be able to make those educated choices, really. So someone's just put the Armed Forces pensions, would a POD need the CETV or CEB that the Armed Forces charge for? I think a CETV costs in the region of £150 rather than a free military personnel can request. Great question, Tanya. It depends case specific. If the pension's in payment, the Armed Forces are quite right to charge the £150. Most final salary schemes would do that anyway. You would need the cash equivalent transfer value plus copies of P60s and pension income forecasts to be able to create that expert witness report. Oh, Julie's saying we need to end at 11:40, which is fine. We've got 8 minutes then, Julie. Just cut us off when we've run out of time. Sharon's answered some of these questions, which is great. Can your poll reports also take into account options for division of equity in the house as an offset? Yeah, they do that as a basic anyway, Julia. You just give us the data as we've shown in the pension discovery meeting, and we'll make it specific to that specific property as well when we're looking at the equity, not the debt. Simon's saying great session, thanks Simon. Can the slides be shared? So interested and helpful. Yeah, Julie's going to arrange to do that, Sarah, for everybody. Can you share your letter of authority with us to use it, please? So Adrian, that's on our website. So assuredwep.co.uk. If you go into the forms section on there, there's a draft letter of instruction to an expert. Will teachers' pension CVs now include the updated benefits? That's from Laura. What's happening with the teachers' pension, Laura, is if they've stopped doing anything at the moment. Because they've pressed the button in the background, they're not issuing CETVs at all at the minute, and they said it could be up to 5 months, maybe even longer. But what we'd get now is that the income's changed and the tax-free cash has been changed, and people can see that on their total reward statement, but you'd still have to wait for the CEV from the scheme, but it's just taken such a long time. Most people just saying thanks. Cannot find the LinkedIn link. Frank, if you go to my LinkedIn page, which is Mark Jones IFA, just search me on there, you'll see that I posted that poll yesterday. Thanks. Want to get the slides. John Stebbings saying excellent presentation, thank you, and you're so right about female pension outcomes. Thank you for agreeing with me, I think so as well. Can you help with the letter of instruction and discovery meeting, then also do the poll report all within mediation? That's from Sarah Manning. Yeah, we do that, Sarah. So most people come to the pension discovery meeting, and because we've got all their data and because we've explained it and helped them through the letter of instruction, we can't finalise it, as I said. If they then want to come to us and get the report from the other team that sit alongside us, then they can do that as well. That's it. That's all the questions that are on there, and that's exactly 11:35. So that's fantastic. Does anybody just want to open the case up to questions now? If anybody else has got any questions before they go, and we'll try and answer it. Otherwise, we'll call it a day for today, and hopefully you have a really good week with all the other sessions that you're running. I don't believe there's any more questions at this stage. So, Julie, I'll hand it back over to you if that's okay.
Thanks, everyone. Yeah, we'll end the recording now, and it will be available on the website probably next week, if we're being realistic. Thanks, everyone. Bye.
Thank you.